Hello, everyone, and welcome to Uncivil Law, and I hope you're having a great day. For today's stream, we're going to talk about Judge Pauline Newman. Judge Newman is a judge on the Court of Appeals for the Federal Circuit, which deals with patent law issues. They're the only Court of Appeals that deals with patent law issues because Congress wrote it that way. And Judge Newman has been on the Court of Appeals for the Federal Circuit since it was invented. In fact, before it was invented, she was on its predecessor court as well. She has been there for a hot minute. She's also been one of the most influential judges on the Court of Appeals for the Federal Circuit because she's known as the Great Dissenter. Because she dissents a lot. So she is a woman who has her own opinion and is not afraid to express it. And she is a bit of a curmudgeon, and I'm here for it. And, basically when it comes to patent law, her attitude could be roughly summarized as, don't talk to me about the old magic. I was there when it was invented. Because she was there when it was invented. And she has been one of the most influential people on the Court of Appeals for the Federal Circuit. Well, she's 98 years old, and her fellow judges of the Court of Appeals for the Federal Circuit have collectively decided that she is disabled. She's not feeling it, though. So they have removed her. Well, they haven't removed her. They have prevented her from taking on any new cases. They've said, Judge Newman, we think that you're disabled, and we're not going to let you hear any new cases. So you can still be a federal judge. You're just not able to hear anything. And she's not happy with that because she's like, no, I'm fine. Maybe I'm a bit of a curmudgeon and, I don't agree with you guys, but I'm sane. I'm, nothing wrong with my mental fitness. Maybe I can't keep a step the same as when I was young, but, I'm doing fine. And she thinks it's personal and retaliatory. So anyways, she has filed a lawsuit against the Court of Appeals, which is hilarious, right? She is suing the Court of Appeals for the Federal Circuit. That's fun. For basically violating the Constitution. She's like, the Constitution says, Article 3 says, I'm appointed as a federal judge unless removed, for violation of good behavior. And it's Congress that gets to do that, not you guys. So you guys basically don't have the power to remove me. I'm still here and I'm still kicking and I want to hear cases and you can't stop me. Ha ha ha. Well, she has lost up to this point. So she's decided to go to the Court of Appeals boss, the U.S. Supreme Court, which could be fun for a lot of reasons, to be honest, because there was a time for about 25 years, give or take, depending on how you measure such things, from the time the Court of Appeals for the Federal Circuit was invented in 1981. For about 25 years, the Federal Circuit was never overruled ever. They just kind of sat there and did their thing. And then the Court of Appeals for the Federal Circuit started thinking it was the Supreme Court. And then the Supreme Court started beating it down for a while. So they've actually been a bit of a whipping boy for the U.S. Supreme Court for a hot minute, as they try to remind the Court of Appeals for the Federal Circuit that, no, actually, you are not the Supreme Court. We're the Supreme Court, and we will make you our bitch. So this could be fun for that reason, because maybe it's another opportunity. The U.S. Supreme Court wants to make the Court of Appeals for the Federal Circuit its bitch, and I'm here for it. So we're going to discuss this case. Okay, so we have petition. In the U.S. Supreme Court, we've got Pauline Newman, Honorable, the judge of the United States Court of Appeals for the Federal Circuit, versus Kimberly Moore in her official capacity as Chief Judge of the United States Court of Appeals for the Federal Circuit, Chair of the Judiciary Committee, and all that stuff, blah, 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 blah. So yeah, she's suing her court. So we're going, this is the best, I don't know, soft sit or pro se or whatever you want to do ever of all time. Federal judge versus their own court. You got to love that. You got to love suing your own court, and I'm here for it. So let's read the summary of the issue. The Disabilities Act authorizes each circuit's judicial council, after investigation, to order that, on a temporary basis for a time certain, no further cases be assigned to a judge who's engaged in misconduct or has disability. I'm not sure either one applies to Judge Newman, by the way. The act allows these orders to be reviewed by the Judicial Conference of the United States, but it limits further judicial review of the council's orders and determinations. All orders and determinations shall be final and conclusive and shall not be judicially reviewable on appeal or otherwise. We'll see. Nothing in Section 357C, however, even purports to prevent litigants from seeking prospective relief that would restrain the council from issuing orders in the future. Based. In March of 2023, before any investigation, Chief Judge Kimberly Moore of the Federal Circuit told Judge Pauline Newman that she had been removed as an active judge and she could either immediately retire or negotiate senior status. Which, that's kind of the same thing, to be honest. But, never mind. Judge Moore and the Judicial Council of the Federal Circuit then issued a series of administrative orders that prohibited Judge Newman from hearing or participating in any cases at a panel or en banc level. So you no longer, you can call yourself a judge and cosplay, but you can't actually do the judge thing. These orders are ultra vires, meaning without power, unlawful, and unconstitutional. Judge Newman has challenged them and sought to enjoin the Judicial Council from issuing similar orders in the future. The D.C. Circuit, however, citing a 2001 decision of that court, held the relevant law's bar on judicial review allows her to assert only facial constitutional claims that challenge the constitutionality of the provisions of the Disability Act. Why? I don't know. Why not as applied, but okay. And strips the courts of jurisdiction to consider any as applied challenge. I don't know about that either. The questions presented are, does the relevant law bar on judicial review of previously issued orders and determinations apply to ultra vires acts that exceed the scope and authority conferred by a Disability Act and the Constitution? And does the relevant law bar on judicial review of previously issued orders and determination deprive a court of jurisdiction to consider claims that seek forward-looking relief to enjoin forward-looking actions? So she's like, well, the law is what it is, but it only goes as far as it goes. And I'm not trying to challenge its existing orders. I'm trying to prevent it from issuing orders in the future. So I want some injunctive relief to prevent them from acting. Okay, exciting. All right, so then we have that statement of relay cases, denying relay cases, table contents, we'll skip that, blah, 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 blah. All right, the petition for the writ of certiorari. The petition presents questions concerning crucial constitutional and statutory aspects of lifetime tenure and judicial independence, especially the availability of judicial review for an intra-branch infringement on the judicial service. Yeah, this could be a lot of fun in a lot of different directions. These questions affect the very independence of Article 3 courts and potentially affect every member of the federal judiciary and every litigant who appears before them. For 3 years, the Federal Circuit has been operating shorthanded because judges of that court have summarily removed its longest-serving and most storied jurist from the bench. I mean, Judge Pauline Newman, as I said in the introduction, was there basically when this was invented. She's been there since she's been there basically since they invented the idea. She was the first judge appointed to the Court of Appeals for the Federal Circuit ever, I think. And in any event, she's incredibly influential in multiple different domains. Just take a look at her history. She's unbelievable. She's a powerful, thoughtful, wise woman who makes other people their bitch because she has her own opinion and she's not afraid to express it. So she will write dissents no matter what if she feels that way, which, to be honest, I'm here for it. I'm here for a judge saying what they think and putting what they think. And, if she doesn't agree with everyone, then she's willing to go it alone, and I'm here for it. She is my hero. She is great. So, yeah. The D.C. Court of Appeals held that the Judicial Council's Reform and Judicial Conduct and Disability Act bars review of unlawful actions taken against Judge Pauline Newman. This administrative removal of a judge who is famous for dissenting from her colleagues, and how, by those same colleagues with judicial refusal to review the merits of the action, undermines judicial independence that's a vital function of our constitutional design. Every judge who gets crosswise with her chief judge or colleagues must now worry whether similar tactics could be used to remove them. Fair point, right? If you're just a guy, if you're a judge who's just a pain in the ass because you have your own mind and are willing to write opinions expressing your thoughts, then maybe this can be used against you too. Fair point. Judge Newman has continued to speak and write before the legal community, and no finding of disability has been made concerning her in the years since the unlawful restraining orders began. She voluntarily underwent and passed 3 expert evaluations of her mental fitness and was reported as having the mental ability of someone's decades younger. She has been suspended longer than any federal judge in history. The length of suspension, the apparent intention to keep her off the bench permanently, the same judges acting as complainant, witnesses, and judges, which there's that too, and refusal to transfer the matter to another circuit for a neutral investigation are unprecedented. The Disability Act allows each circuit to investigate complaints of judicial misconduct or disability. After investigation, the Disability Act authorizes the Judicial Council of each circuit, consisting of all the active judges of the circuit, to order that on a temporary basis for time certain, no further cases be assigned to a judge having found to engage in misconduct or have disability. These temporary suspension administrative orders of the Judicial Council may be reviewed by the Judicial Conference of the United States. Apart from this review by the Judicial Conference, orders and determination of the Judicial Council are final and conclusive and shall not be judicially reviewable on appeal or otherwise. The Disability Act does not authorize the Judicial Council or anyone else to act in violation of the Constitution. Yep, there's that pesky thing. So administrative orders and determinations described in Section 357C cannot refer to everything that happens to be labeled to an order or determination that emanates from Judicial Council, a special committee, or Judicial Conference. Instead, the relevant law should be read as limiting to orders and determinations that Congress has constitutionally authorized in the Disability Act. I agree. The construction of Section 357 preserves the court's jurisdiction to entertain collateral attacks on previously issued orders and determinations that are ultra vires because they violate the Constitution or exceed the scope of statutory powers. Further, even if Section 357 can be viewed as limiting judiciary from disturbing past orders or determination, it allows litigants to seek prospective judicial relief that prevents the issuance of unlawful or allegedly unlawful orders in the future. Section 357, by its terms, turns entirely on the type of relief that a litigant is requesting. Those who seek to enjoin the issuance of further orders or determinations may proceed with their claims, regardless of whether the claims are rooted in statutory or constitutional arguments. The case law of the D.C. Circuit, however, holds that the application of Section 357 depends not on the type of relief being sought, but on the type of claim. Under the law of the D.C. Circuit, a litigant may challenge and ask the court to set aside a previously issued order whenever a litigant brings a facial challenge to provisions of judicial conference, even though the statute purports to bar all judicial review of an order or determination. At the same time, the D.C. Circuit has invoked the relevant law to block litigants from bringing statutory or as applied challenges when challenging a judicial constitutional authority under the Act, even where a litigant seeks prospective relief to restrain the counsel from issuing orders or determinations, which I don't quite understand that. I mean, maybe it makes more sense when you go read the decision. I couldn't say, but that seems odd, right? If you can bring a facial challenge, like this is invalid in all contexts, then why shouldn't you be able to, in the first instance, to bring a facial challenge? This is unconstitutional as applied to me. Or saying, that's not what the statute says. That they're reading the statute wrong. I don't know about that. Law Girl says, can the Judicial Review Board just claim their authority to suspend is authorized by another piece of legislation or the Constitution itself? Well, the Constitution itself would be an interesting argument. That would be an interesting argument because it would be the Constitution allows federal judges to sit for good behavior. Good behavior is the magic word. Now, what exactly does that mean? And who gets to make that decision? So to date, we've interpreted that as Congress being impeaching, but could it be something else? Could good behavior be this? Could this be a valid method of determining good behavior? I don't know the answer to that question. We know that impeachment is a way to determine whether or not good behavior applies, but Congress has the power to make laws to, do constitutional things. The Constitution says good behavior, so Can they turn it over to some other body to make the determination? I don't know. Good question. Maybe that's the question that they're trying to decide. So could be fun. It's fun in a lot of different directions. Also, why aren't you a member of the channel, Law Girls? Just, interestingly. But thank you for being here. The Judicial Council of the Federal Circuit has issued a series of 3 one-year suspension orders that prohibit Judge Newman from hearing or participating in any cases at the panel or en banc level. How can legislation stop the Supreme Court? Because the Constitution says so. In Article 3, it says that the jurisdiction of the Supreme Court can be determined by Congress. So it says so right in Article 3. Go read it. Go read Article 3 and you will know the answer to your question. In response, Judge Newman sued the council and sought relief that it was set aside the previously issued suspension orders, as well as prospective relief that would enjoin the council from renewing or issuing similar suspension orders in the future. But lower courts were bound by the holding in McBride, which led the district court and the DC Circuit to consider only Judge Newman's thank you, Ipsit Dixit, for the 20 gift memberships, very appreciated. To consider only Judge Newman's facial constitutional challenge to the Disability Act case suspension provisions. In applying McBride, the district court and the DC Circuit held that Section 357 barred them from considering any of Judge Newman's remaining claims on the merits, including her statutory and as-applied constitutional challenges to the consul's authority, even though Judge Newman was challenging ultra-virus actions and determinations, as well as seeking prospective relief to which Section 357 is inapplicable. Judge Newman sought rehearing en banc and asked the DC Circuit to reconsider McBride, but the petition was. You were a member at one time, it didn't work out. I don't know what that means. Does that mean that you don't like my channel? I'm confused. I don't understand. What do you mean it didn't work out? I don't understand. The DC Court of Appeals issued its opinion. Judge Newman filed a timely petition for rehearing, but the DC Circuit denied in the rehearing en banc. The court has jurisdiction. Okay, statement. For the past 3 years, Chief Judge Kimberly Moore, acting as complainant and leading the administrative process, has sought to remove Judge Pauline Newman as an active judge. Chief Judge Moore has acted on the pretense that Judge Newman is physically and mentally unfit to continue serving as judge, even though Judge Newman, at age of 98, remains unusually cognitively intact for a woman who appears 20 or more years younger than her stated age. And even though, yes, she's appealing. That's what we're doing. You like my channel, but you don't want to be a member. I don't understand. Something is not squaring in my mind. Even though this court only 2 terms ago announced a ruling that reversed 10-2 en banc Federal Circuit and adopted much of the reasoning in Judge Newman's dissent from the en banc decision. Judge Newman has resisted Chief Judge Moore's campaign of intimidation and continues to hold office in name only as a Federal Circuit judge in active service. Chief Judge Moore has invoked the Disabilities Act improperly to perpetually sideline Judge Newman until she gives into the bullying and retires or takes senior status, doing far more than suspending her from new case assignments. I didn't read your 36-month message. Well, sometimes I miss messages. It's true. Well, sometimes I miss a message, or sometimes I'm in the middle of something and can't read a message right away. I try to address messages as they come in best as I can. But sometimes I miss a message, or I'm deep in thought with something else. So it's possible. I mean, I have to do other things sometimes. I do my best. Is Travis here? Hi, Travis. This is some good shit, Travis. This is some hardcore constitutional shit, Travis, that we're doing right now. And I'm here for it. I don't know whether or not the Supreme Court wants a piece of this or not. I don't know, ma'am. I don't know. But as of late, they have been trying to beat up on the Court of Appeals for the Federal Circuit. So I have to give Judge Newman a little bit of bonus credit, or bonus probability, because the U.S. Supreme Court has been recently trying to make the Court of Appeals for the Federal Circuit its bitch. And so this is another opportunity to do so. So that's got to help Judge Newman's odds. You know what I'm saying? The Judicial Council Reforms and Judicial Conduct and Disability Act. Thank you, Ryan, for the 10 gift memberships. Very thoughtful. Judicial Council Reform and Judicial Conduct and Disability Act, also known as the Disability Act, allows the Judicial Council of each circuit to investigate allegations of misconduct or disability against its judges. In practice, whenever allegations against a circuit judge have advanced beyond preliminary investigation stage, in every prior case, the chief judge or judicial council has requested and been granted a transfer to another judicial council. That is, chief judges have only kept complaints against fellow circuit justices when dismissing them, leaving any more substantive investigation to another council. The process begins when a written complaint alleging misconduct or disability is filed with the clerk of Court of the Appeals for that circuit. The chief judge of the circuit may also identify a complaint by written order, even when no complaint has been formally submitted. Nice. The chief judge of the circuit must promptly review the complaint and either dismiss it, transfer, or else convene a special committee to further investigate the allegations. This has nothing to do with money, as far as I'm aware. If a chief judge convenes a special committee, then the special committee must conduct an investigation as extensive as necessary. After concluding its investigation, the special committee must file a comprehensive written report thereon with the Judicial Commission of the circuit. Pro Gamer for 37 months. Hello from Brussels. Kurt, aren't all federal judges appointed for life? Yes. Which ones are elected? None of them. Could you become a judge? Sure. Who indicts the bad ones? Congress. Thank you for your membership. When the Judicial Committee receives a report from the Special Committee, the Disability Act allows the Judicial Council to conduct additional investigations or dismiss the complaint. But if the Judicial Council declines to dismiss, the Disability Act requires the Council to take appropriate action, which may include one or more of the following. Yeah, this issue has been going on for a hot minute. Yeah, an honest doubter. This issue has been going on. I've covered it periodically, and I'm on Team Judge Newman over here because she's cranky and ornery and a pain in the ass, and I love it. So she's great. Notably, the Disability Act does not authorize actions. How many federal or other appointed judges were not elected judge? I don't know. I can name at least one notable one. Justice Kagan. There's that. So I can name at least one notable judge who was appointed without ever being a judge before. Justice Kagan. There's one. So, Notably, the Disability Act does not authorize actions that would prohibit a judge from participating en banc or prevent a judge from continuing to hire law clerks. If the judge at issue is an Article III judge, then the council may also issue a certificate of disability or ask the judge to voluntarily retire. The Disability Act expressly prohibits the Judicial Council from removing the judge from office. A judge who is aggrieved by the action of the Judicial Council may petition the Judicial Conference of the United States for review. But the Disability Act limits judicial review of orders and determinations issued under the Act. Except as expressly provided, all orders and determinations shall not be reviewed. Thank you, an honest debater, for becoming an uncivilian. It is appreciated. I probably should go back to only answering questions from members. But in order to do that, I have to figure out how to filter the chat again on my side within OBS. I used to be able to do it. I have to figure out how to do it again. And I'll get back to you. It was one of the extensions, if I can remember which one exactly. I think it was HyperChat. On December the 15th of 2022, Judge Newman authorized one of her characteristically excellent dissents from a 10-2 en banc. This court later adopted much of Judge Newman's reasoning when it reversed the Federal Circuit. Some 2 months after Judge Newman wrote that dissent, Chief Judge Moore removed her from normal panel assignments. The Supreme Court might do this just to beat the Federal Circuit around. I feel like there's a non-zero chance. This is a tough sell for Judge Newman, to be honest, but they want to beat the Federal Circuit up. So you got to give them some odds. Less will turn in? Well, maybe, but maybe then people will respond to me. People will become members. So maybe less people will respond, but oh well. Maybe people should become members. It is only 99 cents a month to join. In fact, for the purposes of today's exercise, I'm going to do that. So in order to do that, I have to do it the hard way. Let's see, how do I do that on my end? It's been a while. That's HyperChat. Okay. All right, so if I do this, and then go live, okay. All right, great. So now that will make it so I can only see the member chats for the moment. Okay, great. All right, pressing on. Let's go back to this. The next month, on March the 8th of 2023, the Judicial Council, I need to figure out how to get HyperChat working back in OBS. This is not easy to do it this way. No. All right, we'll see how that can work. No. All right. The next month, I really got to figure out how to work in OBS because it's just too many windows. The next month, on March the 8th of 2023, Judicial Council ordered that Judge Newman may not hear any more cases. And Chief Judge Moore told Judge Newman she could either retire or consider senior status. Judge Newman refused. Then on March the 24th of 2023, Chief Judge Moore acted on her own initiative to identify a complaint against Judge Newman under the Disability Act. Chief Judge Moore alleged that there had been probable cause to believe that Judge Newman's health had left her without capacity to perform the work of an active judge. To investigate Judge Newman, Chief Judge Moore convened a special committee comprising Chief Judge Moore and Circuit Justices Sharon Prost and Richard Tarinto. The order of March the 24th of 2023 relied on personal knowledge of Judge Newman's Federal Circuit colleagues. Although none of them had initiated a complaint, Judge Moore claimed that judges and other staff had brought concerns about Judge Newman to Chief Judge Moore's attention based on personal experience. The order also referred to statements that Judge Newman had made during the deliberations with other judges when no one other than federal judges were in the room, and stated that fully half the judges had expressed concerns about Judge Newman. The order falsely asserted that 2 years earlier in 2021, Judge Newman had suffered a heart attack and undergone coronary stent surgery. Based on the investigations that was by Chief Judge Moore and based on accusations leveled by her fellow Federal Circuit judges, Judge Newman asked the Chief Judge and Special Committee to transfer the investigation to another circuit, given that members of the Special Committee would be serving as witnesses and knowing that established routine practice of transferring complaints against circuit judges requiring more than minimal investigation. In 99 cents a month, I mean, it could, I literally can't charge less than 99 cents a month. So, there's that. I mean, despite the blatant conflict of interest in serving simultaneously as a complaint witness and judge, the chief judge and special committee members denied the request. Before the investigation even began, Chief Judge Moore removed Judge Newman from more normal panel assignments. So that is pretty off, right? They didn't follow the procedure. So the procedural aspects of this might be enough for the Supreme Court to intervene. This was improper because the Disability Act does not authorize sanctions or suspension until after investigation concludes. When Judge Newman emailed Chief Judge Moore and asked her to reconsider her exclusion of the calendar from the entire June hearing calendar, Chief Judge Moore rebuked Judge Newman for replying to this email and one relayed to clerks via an email list named All Judges. Because that list included the email address of clerks and staff, Chief Judge Moore declared the use of the email list possible judicial misconduct. She broadened the special committee's investigation to include Judge Newman's disclosure of confidential employment dispute matter and statements made in regard to the matter. Nice. So by bringing light to the investigation, they're trying to blame her for that. The special committee ordered Judge Newman to submit to neurology and neuropsychology testing by doctors chosen by the committee. The committee also ordered Judge Newman to provide her hospital records, medical, psychiatric, or psychological, and other health professional records to the committee, selected neurologists. In response, Judge Newman submitted expert reports from Dr. Ted Rothstein and Dr. Regina McCurry. Based on hours of testing and observation, testing that her cognitive abilities are fully intact and she remains capable of performing her functions in office. The special committee rejected these expert reports and declared Judge Newman guilty of misconduct for refusing to cooperate with the committee. It recommended that Judge Newman not be permitted to hear any case at the panel or en banc level for a period of 1 year, subject consideration of renewal. The Judicial Council approved the special committee's recommendations. The JC&D committee denied her petition on February the 7th, 2024, affirming the suspension order while leaving her constitutional arguments unaddressed. As the DC Circuit put it, in this case, neither the Judicial Council's orders nor the JC&D committee's decisions explicitly reflects genuine consideration of Judge Newman's constitutional arguments. None of the orders appears to address any argument by Judge Newman that her suspension violates the Constitution by effectively removing her from office. The JC&D committee acknowledged that Judge Newman argued for transfer in constitutional terms, but the order does not discuss constitutional due process law. On September the 6th of 2024, 14 days before the expiration of the 1-year order, the Judicial Council renewed Judge Newman's suspension for a second year. On August the 29th, Judicial Council issued a third 1-year suspension. Judicial Council has continued issuing and renewing these 1-year suspension orders because Judge Newman has not agreed to receive a mental evaluation from a neurologist chosen by the committee. The upshot is that Judge Newman has been barred from exercising any functions of her office since November the 8th of 2023, the date on which she issued an opinion. Chief Judge Moore has prohibited the Judge Newman from sitting en banc, leaving the Federal Circuit operating a judge short of a statutory allotment and in violation of statute requiring all active Federal Circuit judges to sit en banc unless recused or disqualified. Chief Judge Moore has also cut Judge Newman off from ceremonial functions of the court, as well as pre-publication opinion distributions and administrative matters. She's even prohibited Judge Newman from hiring new law clerks. Judge Newman has, for all practical effect, been removed from office despite Article 3's guarantee of tenure during good behavior, and despite the Disabilities Act's strict admonishment that under no circumstances may the Judicial Council order removal from office, and without impeachment and conviction necessary to remove Senate-confirmed judge office against her will. I mean, that's pretty based. We'll skip the proceedings below because I think we got the sort of the gist of it. All right, the court should grant the petition and restore the critical aspects of judicial lifetime tenure and judicial independence. Should be resolved whether orders and determinations described in the law include ultra vires acts that exceed authority conferred upon the Judicial Council by Disability Act and the Constitution. This court should also make clear that Section 357 allows litigants to seek prospective relief that enjoins future unlawful or allegedly unlawful actions. Plus, by filtering for members only on my side, it also means I'm much more likely to see the member chats, including, for example, membership chats, like, because it won't get, like, someone was saying earlier how I missed their member chat. Because if I filter, so I only see the member chats, then it won't get lost, right? It won't get lost in a sea of chat. So my odds of missing those chats are now substantially reduced because I'm only filtering for those chats. So that means member chats member chats are much more likely to get acknowledged. And so that is a plus for the members. So that's nice. So that works out well for everyone. Thank you very much for Yativis for gifting 20 gift memberships. Travis is not a mod on this channel. The court should grant cert and resolve whether oops. There's no oops to it. I mean, he's not a mod. It's not an oops. Section 357 provides that, except as expressly provided in the section, all orders and determinations, including denials and petitions, shall be final and conclusive. Although the statute refers to all orders and determinations, does not shield from judicial review everything that happens to be labeled an order or determination. Rather, and I can see Tony's chat, so no problem there. Rather, Section 357 exempts from judicial review only orders and determinations made under authorities conferred by a Disability Act. If Judicial Council issues orders raising taxes, pardoning a convicted criminal, or declaring war on Venezuela, this so-called order would not be spared from judicial review on account of Section 357 because it's not an order or determination authorized by the law. I love it. This court has often construed statutes that prohibit judicial review of agency action to nonetheless preserve the court's authority to set aside ultra vires actions. In Johnson versus Robinson, for example, the Congress has prohibited judicial review of certain decisions made by the Administration of Veteran Affairs, declaring that decisions of the administrator on a question of law or fact shall be final and conclusive. No court shall have power to review. The court nonetheless held that litigants could collaterally attack decisions if they're challenging the constitutionality of the act that vested the administrator with decision-making authority. Thank you, Ryan, for the 10 gift memberships. Webster Doe is in a similar vein. The statute in Webster provide the Director of Central Intelligence may in his discretion terminate employee. Thank you, Cherie, for the 10 gift memberships. The statute in Webster provide that the Director of Central Intelligence may terminate employee of any officer or employee of the agency whenever he determines such termination necessarily or advisable. When terminating CIA employee student claimed they'd been fired for unconstitutional reasons, the court held it could review the claim under the Administrative Procedures Act, notwithstanding the prohibition on judicial review of decisions committed to the agency's discretion by law. And rightfully so. A statute such as 50 U.S.C. 403 can never vest an agency official with discretion to violate the Constitution, no matter how sweeping its language. So seemingly absolute discretion conferred by law still left courts with room to review challenges to the CIA director's firing decisions. The Disability Act, like Section 50 U.S.C. 403, cannot authorize Judicial Council or anyone else to act in violation of the Constitution. So administrative orders and determinations described in law should not refer to any order or determination that happens to emanate from the Council, a special committee, or Judicial Conference of the United States. Instead, one can rely on Johnson and Webster to limit the law to orders and determinations that Congress has constitutionally authorized in the Disability Act. The construction of Section 357 will preserve the court's jurisdiction to entertain collateral attacks on previously issued orders and determinations that violate the Constitution or exceed the scope of the statutory powers conferred by the Disability Act. Judge Newman has raised a host of constitutional challenges to suspension orders and claims that the Judicial Council has exceeded the scope of its statutory powers and violated the Constitution by effectively removing her from office despite lifetime tenure. The court should grant certiorari to decide whether and to what extent Judge Newman can collaterally attack the previously issued suspension, notwithstanding the prohibition on judicial review, on the ground the statute shields only orders and determinations issued within the scope of conferred authorities. McBride failed to recognize that Section 357 preserves the rights of litigants to sue for prospective relief, then joins future orders, and at most bars judicial reviews of past orders and determinations. It does nothing to stop Judge Newman from suing to enjoin a judicial contact's future actions. Let me do one thing real quick. Talk amongst yourselves briefly. All right, let's try that. Let's see. How are y'all doing today? Feeling good? Good. I need to record some content for this week today, too. I have a couple things I need to do already. It's 12 o'clock, and I feel like I'm already out of time. You know, it's just the way the days go sometimes. Yeah. Oh, Lord. Are we on green yet? No, but, you know, it seems to be improving, which is good. Don't necessarily feel super pretty today. Not necessarily 100% my best today. But it is partly sunny. Well, actually, to be honest, it's mostly cloudy. But at least some sunshine is coming through, and it's, you know, life is not so bad. Where were we? And nothing in Section 357 bars courts from enjoining future conduct that's alleged to violate statutory constitutional rights. The law does not bar such relief as readily apparent from its text. The statute accords non-reviewability only to orders and determinations that's already issued and blocks judicial review only of those extant orders and determinations. Is Newman from the KF case? I don't know what the KF case is. And probably not. If it's a case you've heard of, probably not. This leaves an accused judge free to sue for prospective relief, lest the improper and illegal orders determinations be repeated. Here, such relief would prevent Judicial Council from renewing or reissuing suspension orders. And there's certainly no clear indication that Section 357 strips the court of jurisdiction, consider claims that seek prospective relief. McBride led the D.C. Circuit panel to conclude that Judge Newman could pursue only her facial constitutional challenge to 28 U.S.C. 354 because McBride held that courts could consider only facial challenges of the sort when judges sue in response to suspension orders. Yeah. But Judge Newman is seeking prospective relief in addition to remedies that was set. Yeah, she's on the Court of Appeals for the Federal Circuit. You have never heard of this judge. She runs in patent law circles. So she runs in the circles I used to run in. She doesn't run anything reflecting the public consciousness. You've never heard, I'm sure, of a Court of Appeals for the Federal Circuit judge or basically any of their decisions probably ever, because they deal in subject matter specific stuff that is not in the public consciousness. So they no one knows these people. No one knows these people exist. Lord have mercy. At the very least, this court should grant the petition for cert, vacate, and remand in light of the intervening decision, which forecloses any construction of the law that would close the door on Judge Newman's claim for purely prospective relief. The law establishes jurisdiction stripping provisions, such as the relevant law, that may be construed according to their enacted language, and they cannot be expanded beyond their words to reach situations that might seem similar that fall outside the category the statute has. More specifically, the relevant law provides that grant or denial of authorization by a court of appeals to file a second or subsequent habeas application shall not be appealable and shall not be the subject for a petition. Not by the way that you necessarily care, but I'm going to be going away from live cases. From live for the most part. I'm going to try to release a daily story every day at 12:15 Central. That is sort of my now plan. And so we're going to try to do that and see how that goes for a while. So I want to record some content so I can, have a couple in the bag. I'd like to try to get 3 stories recorded and done today. So that would be nice. And we'll see how that goes. And then I've got to file shit. I've actually got a lot of stuff to do in my case in the Western District too. I've got to file a miscellaneous letter with the judge. I've got to complete discovery and send that off. I've got to send a letter to some other people on behalf of my client. And I think there's a 4th thing I have to do today too. It's going to be a busy day. Lord have mercy. Plus, I know opposing counsel is about to go bitch to the judge. So, I have to get prepared for that bullshit. So I have to steel myself for that bullshit. So that's fun. Okay. Beau produces any court from expanding law beyond its literal terms or using the law to decline jurisdiction over anything other than collateral tax on extant orders and determinations. And Bowen further requires courts to find clear indication in statute's language before construing the law to deprive courts of jurisdiction and claim for prospective relief. Membership literally is only 99 cents a month. I literally can't make it any cheaper. What can you buy for 99 cents? Not much, man. There isn't even a dollar menu anymore. You can't see the text I'm reading, can you? There's not even a dollar menu anymore. You can't buy much for 99 cents a month, man, but you can buy a month of membership with Uncivil Law. That's not a bad deal, ma'am. That's not a bad deal. It's pretty good, ma'am. One of the reasons I made it cheap is so that, because when you're a member of a lot of channels, that can add up fast. When people are charging $5 every time, that can add up pretty fast. But by only charging $1, it doesn't add up too much. So do you have $1? $1. $1. $1. What can you buy for $1? Not much, but you can buy a membership at Uncivil Law. It's a pretty good deal, ma'am. Pretty good deal. Yeah, even the Dollar Tree isn't $1. Yeah, there's no dollar menu at McDonald's anymore. Can you even buy something for $1 at McDonald's? I'm not even sure. Probably a small fry. That's about it. Yeah, so we offer value over here, man. Neither McBride nor the panel opinion applied the clear indication rule of Beau before interpreting Section 357 to block Judge Newman's statutory and as applied constitutional claims. Yeah. Imagine you had to pay for a university education, I know. Nor could they, as Beau was announced 11 days after the D.C. Circuit denied Judge Newman's petition for rehearing. If the court's unwilling to grant certiorari and decide the question presented, it should at least grant, vacate, and remand the petition so the D.C. Circuit may reconsider its decision in light of the intervening ruling in Beau. This court should grant the cert despite the absence of circuit split. Yeah, I don't think circuit split is normally how we get to the Supreme Court, but this is definitely in a category where the lack of a circuit split is not the thing. So I can't say what the Supreme Court will or will not do, but I feel like Judge Newman's odds are better than nothing. Again, they want to beat the Supreme Court likes beating the Court of Appeals for the Federal Circuit around these days. So that's got to help. Her odds are pretty good. We'll see how it goes. I kind of hope that they'll grant it, just because it'll be fun. McBride has been the law of the D.C. Circuit for nearly 25 years, and the court showed no interest in revising it when Judge Newman sought rehearing. But awaiting further percolation is unlikely to produce a circuit split, as litigation is rare. That's true. That's fair. And the relevant apparent bar on judicial review is likely to deter litigation by those who do not realize that seemingly sweeping language still allows courts to consider claims for prospective relief. But the rarity of litigation over judicial suspension does not diminish the importance or cert-worthiness of these issues, especially in light of recent attacks on the independence of Article III judges. The Constitution provides Article III judges with life tenure and salary protection, so they can apply without fear of retaliation from those who dislike their decisions. Chief Judge Moore is using the Disability Act to circumvent these constitutional protections and attempt to implement a constructive discharge of a judicial colleague with whom she no longer wishes to serve. These heavy-handed tactics cannot be tolerated if the independence of Article III judges is to be preserved. Other judges who are watching what's happening to Judge Newman can only wonder if a similar fate will befall them if they fail to stay on the good side of the chief judge. This court cannot allow the internal politics of the court to sideline a Senate-confirmed judge and threaten the independence of other judges who may fear similar reprisal. All this needs to be nipped in the bud before any damage is done to the Constitution's protections of judicial independence. I think the procedural mechanism is how the Supreme Court does this, right? They don't get into the merits of the thing. The way the Supreme Court solves this without breaking everything is they just go on the procedural aspects, that they didn't follow the procedure. They suspended her before the investigation, so forth and so on. So that's the way they solve it. And they say, therefore, the decision was ultra vires because they didn't follow the procedural path. So they don't have to get into the merits of the thing, because that's a pain, because I don't know which way that goes. So I think the Supreme Court's path here is procedural. And that works. Thanks, New York Renal ND, for 50 months of membership. That's very nice. Judge Newman's colleagues have thus so far succeeded in silencing her frequent dissenting voice on the court, despite a presidential appointment and lifetime tenure. Indeed, her effective removal from the bench has had a dramatic effect on the number of dissents issued in the federal circuit. One recent study concluded that since Judge Newman's removal from the bench, the rate of dissent in the federal circuit has dropped from 12% to 4%. She's a one-man show. There's no denying that. Just losing Judge Newman's own dissent does not fully account for that drop. That means other judges are dissenting less than they used to when Judge Newman was actively participating and setting a good example. Or perhaps what's happened to Judge Newman has raised the perceived cost of dissenting, intimidating some judges at the margins from authorizing dissent. Either way, the federal circuit and those who litigate before it are worse off with the lack of vibrant dissent to simulate more careful thinking and adjudicating. Based. Attacks on the independence and judiciary have been increasingly from both left and right, and from executive, legislative, and even within the judicial branch. For those reasons and reasons above, it is imperative the court step in and issue a strong statement in support of judicial independence and make clear that its only appropriate method of removing a federal judge is through the constitutional impeachment process. Therefore, the writ should be granted. I love this. This is great. I'm here for it. I'm here for it in every language. And, Judge Newman, as I say, is an absolute force of nature. I mean, she's just an absolute force of nature. She is an OG. She is pre-OG. That's how hardcore. She's been there since the beginning. She's been there since before the beginning. She is one of the most influential judges in patent law. Arguably, the only judge who is more influential is Judge Rich, because he wrote the Patent Act. He wasn't a member of Congress. He was a clerk at the time. He was an assistant to a congressman. But Judge Rich wrote the Patent Act. It wasn't Congress who wrote it. It was Rich. And so he wrote the thing, and then he was chief judge forever because, he wrote the Patent Act. But other than Judge Rich, Judge Newman has got to be up there as one of the most influential judges to serve on the circuit, not for least of reasons, her high dissent rate. So she makes people think. And I appreciate that. I appreciate the thinking. And I appreciate her willingness to stand up for what she thinks is right and be a bit ornery and be a bit contrarian, not for the sake necessarily of being contrarian, but because she thinks she's doing the right thing. And I'm here for it. I'm here for a judge thinking and saying what they think instead of just getting along to get along. Not that she's trying to be hostile, but she's not allowing friendship and camaraderie to come in the way of her duty. And I appreciate that. Judge Newman is based. So I think that the Court of Appeals for the Federal Circuit did defy the procedure. I think that Judge Newman's right. I think they went outside the bounds of the way they're supposed to do this. And I think that they wanted to get rid of her for whatever combinations they want to get rid of her. Probably because she's ornery and, pain in the ass. But, they went about this the wrong way. And I think there's a pretty decent chance the Supreme Court will get involved. I think it probably comes down to Chief Justice Roberts, to be quite honest. Since Chief Justice Roberts is the circuit justice for the Court of Appeals for the Federal Circuit, I think Justice Roberts is probably the most decisive vote on this issue. So if Chief Justice Roberts wants it, I think the other judges say yes. And if he doesn't want it, I think they say no. So I think it probably comes down to Chief Justice Roberts because no one else knows patent law. Not that Chief Justice Roberts particularly does either, but he's the circuit judge. So it probably comes down to Roberts to decide this thing. And, I feel like there's a pretty decent chance they pick it up. And if they do, I think there's a pretty decent chance they reverse on the basis of improper procedure. And it's like, go do it. And they don't get into the substantive issue because they don't want a piece of that right now. So they say, go about it the right way and, get back to us. So I think that's the likely conclusion. And they smack the Federal Circuit around. If you got a bet, right? If you've got a bet, it's always a safer bet to bet that the U.S. Supreme Court is going to smack the Federal Circuit around, right? The U.S. Supreme Court has had its favorite circuit from time to time that they like to slap around, right? The Ninth Circuit was their whipping boy forever and a day, right? The Ninth Circuit was the one they like to whip, they like to beat around. And then the Ninth Circuit kind of fell out of favor. And then it was the Sixth Circuit for a while, particularly on habeas issues, which they're still doing. And I think their favorite whipping boy at the moment is the Court of Appeals for the Federal Circuit, because the Court of Appeals for the Federal Circuit thinks they're the Supreme Court, and the U.S. Supreme Court would like to continue to remind them that they're not, and beat them down and make them, remember their place. So, if you're putting odds on this, I figure there's got to be, a decent 40% chance the Supreme Court picks this up. I mean, the issues are important. The issues are, there's not going to be circulation issues. The issues are important, and we can decide on procedural stuff and not get around this. So I figured that odds are pretty good. So we'll look forward to this being docketed, and hopefully cert will be granted, and that'll be lots of fun. Did I weigh in on the Lewis Roman 1201 controversy? No, I have no idea what the controversy is. But since we have some time, although not much because I have other things to do, but since we have a little bit of time, let's take a look and see what the controversy is. And I'll try to opine a little bit because it comes from a long-term member, and this is one of the perks of membership, because then I'll do things, or because you're a member, or more likely do things. I'm obviously not beholden, but more likely do things. So let's take a look at what this controversy is and see what I think on it. It's about the patent law, creators and fair use. Well, that's not DMCA then. If it's patent law, that's not the DMCA. And there is no fair use in patent law. It says in 1201 you can't rip videos. Again, let's take that's a well, okay, let's take a look at it. What's going on? The guy's name is DMCA lawyer. Okay, I'm looking for the video on what's the name of the, is there a name of a video that I can look up about this controversy that I can react to? Can you give me the name of the video to search, and then I'll play it for a little while and we can see what we think? Read the wiki? Okay. I can do that. I can't find anything on his wiki for the search term DMCA lawyer. I'm gonna need something more specific. Can you tell me what to search for on the wiki, or can you give me more instruction, please, without actually giving me a URL, since I don't allow URLs in the chat? Okay. So there's something 2 weeks ago where he did this. All right, let's see what's going on. So he did make a video. All right. Let's see what he says.
Hey, everybody, how's it going?
All right, let's see what's going on here. All right. Okay.
My apologies for talking as fast as I am. I had a scoop of dimetized protein powder that has, it's the Dunkin' Donuts one, which has caffeine in it, and I should never be allowed to have caffeine. If I have a quarter of a cup of coffee and don't finish the rest of it, I will be running fiberglass fish wire through my wall at 5 in the morning to try to get Cat 6 wire going alongside my electrical wiring to my fish pond. I can't handle caffeine. My brain just explodes. I should never be given a stimulant. Caffeine is
the one that's entitled "I'm ending his career." Okay, fine. All right, let's see what this is.
Look into this. Today I'm going to follow up on the 2 videos I did on Denver Metro audits suing fraud or troll. This video is going to focus on the conduct of his attorney, and I want you to really pay attention to the way this man treats people, and then think about whether or not you think it is a good idea that Section 1201 of the DMCA be used in this way. One of my findings throughout life is that when you have abusive laws, you have abusive rules in place, it tends to be the biggest pieces of shit that have the worst possible behavior that end up being the people that use this as an excuse to bully other people. And I'm finding that to be the case the more I look into this. Many people have suggested that I look into the personalities involved, and I don't think that they meant me looking into the lawyer. I think they meant me looking into Denver Metro Audits, who's doing the lawsuit, or the defendant, fraud or troll. But I'm really interested in the lawyer, and the reason I'm interested in the lawyer is because it is the lawyer that has power. What can a YouTuber at the end of the day do to you that has a couple of thousand views per video? Not much. What a lawyer can do is massively fuck up your life. There are people that have tried to sue me because they didn't like what I had to say, and when you're dealing with a lawyer, as the person who was dealing with Deep Cycle Systems Batteries can tell you, or anybody else on this channel where I've discussed their lawsuits, it's very easy to get caught up spending $40,000 to $150,000 to defend yourself. And even if you win, you then have to countersue for damages. You will have to collect. It is a painful process. And many people simply do not have the $400 to $1,200 an hour to pay for an attorney to fight a frivolous lawsuit. So if an attorney is acting in bad faith, they can just say, I'm going to file lawsuits against people that I know don't have the money to defend themselves, and bully them. You can essentially get them to either submit, or I'm just going to force you to court. I see this to be a very distasteful thing to do. So the first thing I need to say before I get into anything else in this video is that I do not disrespect the concept of First Amendment auditing. I think it's a very important thing to do. I have been kicked out of legislative hearings before when I show up with my camera to record these right to repair hearings and to show you what lobbyists say, because I don't have a press pass. I've done many videos in this channel where I show up to legislatures with my camera, I talk to the senators, the assemblymen, the representatives, and I tell them why right to repair is important, and I also try to debunk the lobbyist bullshit. The lobbyists will say things like, Lewis is going to install TikTok on your phone, and it's going to spy on you, and it's the manufacturer that's been installing TikTok to begin with that you represent. Or they say that spectrometers and microwaves will explode when spectrometer is not even a part that's in a microwave. And they'll say that I need a press pass in order to record. Somebody from my audience actually made me a press pass just in case that happens again 6 years ago. Shout out to whoever made this. Or there will be lobbyists that will say that I harassed them or that I violated their privacy by showing up to a public legislative hearing with my camera in a government building and recording what they said at the public hearing. That's not harassment. That's not an invasion of privacy. There's no expectation of privacy in a public legislative hearing. You just don't like the fact that I recorded you lying and hundreds of thousands of people are now going to see it, that you're not used to having listened to your BS or call you on it. So First Amendment auditing is very important. But unfortunately, with everything in life, there are bad apples that get into everything. So I was going over this lawsuit in a recent video that I did where Denver Metro Audits sued Fraud or Troll, and he was saying, listen, the way you use my video is not fair use. So Fraud or Troll uploaded a video that included a lot of Denver Metro Audits' content in it, and he made remarks and criticism on that video. Denver Metro Audits filed a strike on that video saying this is not fair use. You use way too much of my content. Fraud or Troll defended himself, counterclaimed, and actually won. I want you to think about this for a moment. YouTube is a platform where it constantly, willy-nilly gets it wrong and always enforces the strike even when it's incorrect. And here, a channel that's 1/3 or 1/5 the size of the channel making the strike, that's much less authoritative, actually won. I want you to think about this for a moment. It's kind of like if Tim Cook walked up.
Which video do you guys want me to respond to? You guys need to make a decision. Do you want me to respond to this video? Do you want me to respond to something from Larry French? Which video do you guys want? So which one do you want me to do? Is this video okay with you guys, or do you want me to do Leonard French? Which one do you guys like? I'll wait. I'll need to research it. You're assuming I can't figure it out. Which one do you want? Just tell me what you want. This video, a Learn French video, some other. What do you want? Just tell me what you want. I'm going to respond to a video. Which video do you want me to respond to? Pick one. This video, Learn French, something else. Which singular video would you like me to respond to? I'm trying to do this as a courtesy because it wasn't on the agenda for today. I'm not going to go chase video after video after video. Which video would you like me to respond to? This one, Learn French, something else? You want me to? You think French is the way to go? Okay, we'll do French then, if that's what you guys want to do.
In the world of copyright and online content creation, we often talk about the fair use of another creator's material. Fair use is the legal answer to the question of how much protected material can I use to make my creative point before my use becomes copyright infringement. Well, now, nearly 30 years after the passing of the Digital Millennium Copyright Act, the United States District Court for the Northern District of California is taking up a different kind of fair use question. Judge Virginia DeMarchi has denied a motion to dismiss a DMCA anti-circumvention claim, allowing the claim to proceed. When someone wants to make a fair use of another's work, they have an additional major hurdle to overcome, obtaining a copy of the original work. The claim in today's case is that plaintiff's YouTube video was illegally downloaded in order for a fair use to be made. The most famous case on this channel is, of course, Matt Haas versus H3H3, aka Hossein versus Klein. My best pronunciation to date. Sorry, Matt. In that case, H3H3 Productions mocked and criticized Matt Haas using clips of Haas's own video. The judge there decided that the Kleins had made a fair use of Haas's video, and therefore the Kleins were not liable for copyright infringement. Quote, according to the First Amended complaint in this case, Mr. Cordova owns and operates and creates content for a YouTube channel called Denver Metro Audits. Mr. Hunault and Mr. O'Heary own and operate a YouTube channel called Frauditor Troll Channel. Mr. Cordova is the owner of copyrights in 3 videos in this action. The First Amended complaint alleges that between February of 2022 and October of 2023, defendants published on YouTube several videos containing content originally published by Mr. Cordova, including 3 videos incorporating significant portions of Mr. Cordova's videos without authorization. In addition, Mr. Cordova alleges that defendants used various techniques to circumvent YouTube's technological measures, which are designed to prevent unauthorized copying or downloading of videos, to obtain videos of Mr. Cordova's videos from his YouTube channel. In June of 2023 and October of 2023, Mr. Cordova submitted 12 DMCA takedown notices to YouTube requesting removal of defendants' videos. YouTube removed 11 of the videos. Defendants submitted DMCA counter notices on 11 of the videos seeking reinstatement. Now Mr. Cordova asserts 4 claims against all 3 defendants. 1, copyright infringement of 2 copyrighted videos in violation of 17 U.S.C. Section 501. 2, misrepresentation on their DMCA counter notices in violation of Section 512F. 3, a declaration that the videos do not qualify as fair use. And 4, the one we're concerned about, unlawful circumvention of technological measures in violation of 17 U.S.C. Section 1201A. Mr. Cordova seeks damages, injunctive relief, declaratory relief, and attorney's fees and costs. For today's video, I'm focused on the 4th claim, the unlawful circumvention of technological protection measures, aka DRM, or digital rights management, to obtain the source video in order to make a fair use. Why now? Why wasn't this addressed in the last 30 years? Well, because that's how the law and courts work. A plaintiff needs to bring a case, needs to make the anti-circumvention argument. A defendant needs to litigate that issue and not settle, and a court needs to evaluate the issues and make a ruling. Apparently, we don't have extensive case law on this issue, and yes, I'm getting back to the H3H3 case. First, back to the court. Mr. Cordova asserts a claim of unlawful circumvention of technological measures. Section 1201A1 prohibits the circumvention of any technological measure that effectively controls access to a protected work. To state a claim for violations of 1201A, a plaintiff must plausibly allege that the work at issue was protected by copyright, the copyrighted work was protected by a technological measure, and the technological measure was circumvented in order to obtain access to the copyrighted work. The DMCA defines a technological measure that effectively controls access to a work as a measure that, in the ordinary course of its operation, requires the application of information or a process or a treatment with the authority of the copyright owner to gain access to the work. According to the First Amendment complaint, YouTube automatically applies technological measures to published videos that control access to and prevent unauthorized copying or downloading of Mr. Cordova's videos. The complaint also alleges that YouTube's technological measures include rolling cipher technology, which is software designed to prevent unauthorized downloading of videos. This technology encrypts and dynamically alters the video stream's URL signatures to prevent unauthorized downloads. Citing to the MDY Industries case, defendants argue that Mr. Cordova's claim fails and YouTube's technological measures do not effectively control access because Mr. Cordova's videos are publicly available on YouTube. Defendants misread MDY Industries. As the Ninth Circuit explains, the statutory definition of the phrase effectively controls access to a work does not require that an access control measure be strong or circumvention proof. Rather, it requires an access control measure to provide some degree of control over access to a copyrighted work. As one district court has observed, if the word effectively were read to mean that the statute protects only successful or efficacious technological means of controlling access, it would gut the DMCA, because it would limit the application of the statute to access control measures that thwart circumvention but withhold protection from those measures that would be circumvented. Mr. Cordova has adequately pled that YouTube applies technological measures, including rolling cipher technology designed to prevent unauthorized downloading, to his videos on his platform that effectively control access to his videos. Whether the videos may be viewed by the public is immaterial. The complaint refers to the technological measures intended to prevent unauthorized downloading. As other courts have concluded, identifying measures that restrict access to downloadable files are sufficient for the purposes of a 1201A1 claim. The court cites to Ute versus the RIAA, finding allegations that YouTube's technological measures control access to downloadable files was sufficient at the pleading stage. In Edlund v. Basin Electric, the court denied dismissal of a circumvention claim where the plaintiff plausibly alleged that YouTube has many technological protection measures to prevent unauthorized recording and distribution and copying of video content. And UMG versus Kurbanov, finding plaintiff sufficiently alleged a 1201B claim where plaintiff alleged YouTube's technological protection measures included a rolling cipher. The DMCA provides that to circumvent a technological measure means to descramble a scrambled work or to decrypt an encrypted.
Did someone change the logo, the small logo on my channel that goes in the bottom right corner? Yes, someone did. Someone changed it without asking me or my permission. Which moderator needs to have their moderation privileges removed at this point? Where is that setting anyway?
Work, or to otherwise avoid, bypass, remove, deactivate, or impair a technological measure without the authority of the copyright owner. According to the First Amendment complaint, defendants did circumvent YouTube's technological measures by using software applications or ripping utilities or browser extensions specifically designed to bypass YouTube's technological measures. Mr. Cordova alleges that defendants' tools retrieve and decrypt the obfuscated streaming URLs, enabling defendants to make local copies of plaintiff's videos. Defendants argue that the First Amendment complaint relies on conclusory allegations and describes nothing more than defendants downloading or screen recording a publicly available video. Defendants also fault Mr. Cordova for failing to allege what tools were used and when such tools were used. Defendants mischaracterize the allegations in the First Amendment complaint, according to the court. Moreover, defendants cite no support for their apparent contention that a plaintiff must identify in his complaint the specific tools used to circumvent the technological measures or a date on which those tools were used in order to survive a motion to dismiss. As noted above, the court does not consider and weigh defendants' opposing evidence when addressing a motion to dismiss. Drawing all reasonable inferences in Mr. Cordova's favor, again, the motion to dismiss standard, the court concludes that the First Amendment complaint plausibly alleges that defendants circumvented YouTube's technological measures using the described techniques in order to download his videos, and therefore adequately pleads the third element of the anti-circumvention claim. Accordingly, defendants' motion to dismiss the DMCA anti-circumvention claim is denied. And with that simple ruling, the court has left the door open that the DMCA can be violated even when making a fair use of the source material. The problem is that fair use is the embodiment of free speech, of the Constitution's First Amendment in copyright law. Fair use is a right, not a privilege or an exception to the law. You have the right to make certain uses of copyright-protected material if those uses are fair uses. Fair with a capital F, because there's a lot of legal definition behind.
Well, I think Leonard French is... I think Leonard French, by his own analysis, agrees that this is a somewhat novel issue. He seems to suggest or outright say that this issue has never been brought before, or there's no case law on it, because, you know, he said, why has this never come up for 30 years? Well, no one's ever brought it up before. So apparently this is a completely novel issue of law. And so the judge was like, well, there's no case law on it. The statute says what it says. So I'm going to need to think about it for another second. You know, that isn't necessarily to say what the judge will or will not do in the end, but he's not willing to dismiss it out of hand because there's no case law that says it's frivolous. So in the absence of case law saying it's frivolous, and he's like, well, this is a plausible argument under the law, then I need to do a further legal analysis. I can't just dismiss it out of hand because this is a question of law and also a fact about what the what the anti-circumvention measures are, how they were accessed or bypassed or anything else. So the judge doesn't want to dismiss it out of hand. I can't necessarily say I blame the judge because there's no apparent case law on point. And the judge is required, if he's being a good judge, the argument is non-frivolous. And so is a screen recorder or something else an anti-circumvention measure or defeating an anti-circumvention measure? I mean, I'd say no. I mean, ultimately, I'd say no because I'm not defeating anything, right? I've accessed it the way everyone else does by simply loading it. And so I haven't defeated an access measure. I haven't done that. I have lawful access. And then I'm not doing anything to augment or change my access. So ultimately, I think I'd conclude no, but it's a novel idea. And so the judge wants a little bit longer to think about it. So, you know, I mean, ultimately, he's right. This would be a very problematic interpretation. It would make things a lot more difficult. It would basically kill every reaction channel ever. And so that would militate against interpreting it so broadly. But I can't necessarily say I blame the judge in the first instance for not dismissing it out of hand, because it requires a more thoughtful legal analysis so that you can then analyze what's going on, especially if there's no case law on it. So I guess that's my thought on the issue, is that the judge is doing pretty much what they should. And my thought is that after having done that, in the end, I would probably conclude it's not circumventing. But, you know, I need a little bit more factual discussion, a little bit more before I can make such a ruling. So yeah, that's what I think. Okay. Enjoy your Def Leppard concert, Kiska. I hope that works out well. All right, so yeah, that's what I think. And you know, Louis Frostman is going to freak out as he does, and all the rest of it. Wouldn't you have to prove that they use software? Maybe ultimately you'd have to prove that. So yeah, those are issues of fact that might have to be developed. But you know, it might make it past the pleading stage. So at least for the moment, to allow a little bit more thought on that. So yeah, possibly. Unless of course he admitted to it or otherwise showed it, you know, he admitted to using OBS or admitted to recording it. So maybe there are facts already present, but yeah. Yeah. There's a lot of hurdles getting to A to B. There's a lot of hurdles in this interpretation of law, but I can't say that it's so frivolous, because the only alternative, it seems to me legally, is that it's frivolous and therefore should be dismissed out of hand, right? And by frivolous, I mean either it's, you know, batshit crazy on its own terms, or the case law forecloses it. Neither one seems to be immediately true. It's not batshit crazy, and the case law doesn't seem to foreclose it by Leonard French's own analysis. So therefore, the judge, because it makes a plausible contention, should let it go forward and allow things to develop. And either one, it will fail on the factual development because they can't show what they need to show, or it will ultimately fail in the legal analysis, or I suppose the judge will ultimately agree. But yeah, you need, there's more game to be played. It's premature to dismiss this out of hand. That seems right. The DMCA lawyer was soliciting contents for potential lawsuits on YouTube, messing careers, saying, I can sue people making reaction videos. Well, yeah, I mean, that would be correct. Under this interpretation, he would be correct, because pretty much every reactor is reacting in live time. And then they're using an interface in the browser, which can be demonstrated through the actions or otherwise. So, you know, that's what he's doing. He thinks he has a cause of action, and he's soliciting clients for that purpose. So, or at least sending out notices that he can do it. So, assuming that he's complying with the bar's ethics rules when it comes to soliciting clients, then, you know, okay, you know, fair enough. So he seems to be pursuing a cause of action that he thinks makes legal sense. It's novel. And, you know, so, you know, yeah, okay, fair enough. So, I don't know, you know, but that doesn't mean that you can't criticize the lawyer for being a bastard and trying to kill the internet. So, yeah, if you want to criticize him for, you know, being a jerk, I think that's fine too. But there might be some legal merit to it. As a hypothetical judge, I'm not sure that I could dismiss it out of hand either in this current situation. So as a hypothetical judge, I think I'd have to let it go forward for further development. As a hypothetical lawyer, I could pursue those causes of action because they're non-frivolous. So I could find clients who might want me to represent them, and charge them accordingly, and so forth and so on. Is it unethical for lawyers to solicit clients? I'm not going to get into that issue because that deals specifically with state law issues, and it can get very complicated on how lawyers can and cannot solicit clients. So I'm not going to get into that issue right now about whether it's ethical or not, because that's state law dependent among other problems. So I'm not going to get into that issue right now. Did I see a super chat? I don't think so, but let me take a look. No super chats today. There were no super chats today. So no. I don't see any super chats on my back end. When I go to fan funding, there are no super chats there. So no. Are you sure it went through and didn't get bounced? Yeah, the membership milestone chat, which I believe I read or responded to. Yeah, I did respond to the one from Pro Gamer. Oh, okay. There was one from Lynn that said, "Good to see you. I've been missing on some of your content live. Good luck on your case." Oh, thanks. Yeah, I did miss that one. Fair enough. I missed your membership chat. So yeah, fair enough. Okay. You meant membership chat. Okay, yeah, fair enough. Yeah, sorry about that. So I was still off in another world trying to respond to other things as I do. So I still missed it. So the system is not foolproof, but we do what we can. All right, in the moment, I'm going to sign off. And I got a lot of work to do today. And I also have to go to the gym and some other stuff. So I'm going to try to take a brief pause, and then I got some work to do. I'll probably start with recording some video content for this week and then go from there. Until later, my friends, I hope all's well. Cheers for now, my friends, and goodbye.